Hello, everyone, and welcome to the ACC Chicago Annual Illinois Employer Update CLE event hosted by sponsor Baker McKenzie. My name is Deidre Dunn, and I work for McDonald's Corporation. I am on the board of ACC Chicago. These events, as you all know, are only possible with the support of great sponsors like Baker McKenzie, and they have a great program for you today, so we appreciate you taking the time to participate. We do encourage you to look to Baker McKenzie when you have a need for outside counsel. You may know that the ACC Chicago is always interested in continuous improvement and ways that we might improve our programming. So we do welcome your feedback. And after the program today, you will receive a short survey link via email. So please feel free to send us any feedback. We do look at all of those and appreciate all of your feedback. And now I'd like to introduce Bill Dugan, a partner in Baker McKenzie's Employment and Compensation Group, to kick off our presentation.
Thanks, Deidre. On behalf of Baker McKenzie's North American Employment Practice and the entire Chicago team, welcome to our two-part annual Employer Update webinar series, reflecting on 2021 and strategizing for 2022. Thank you for joining us for part one, which will focus on labor and employment. As Deidre said, my name is Bill Dugan, and I'm joined today by my colleagues Liz Ebersol, Goli Rahimi, JT Sharon, Demia Park, Remy Sneed, Remy Belusian, and Brian Wadajewski. Before we get started, on the screen, you will see a summary of the additional housekeeping notes for today. A few things to call out. Our session today is being recorded. The recording, along with the presentation and relevant materials, will be provided in a follow-up communication after the program. And to ask a question, please use the Q&A button at the bottom of your screen. We'll try to respond to your questions during or at the end of the session, or we'd be happy to follow up with you afterwards. As Deidre noted, CLE for Illinois will be provided by the ACC Chicago, and you'll receive your certificate from the ACC via email next week. For other states, a CLE code will be shared later in the presentation. Please be sure to write it down, as you will need it to complete the forms. They'll be distributed in the post-program communication after the webinar. And lastly, at the end of the webinar, please share your feedback with us in a brief 3-question survey. We value your feedback and aim to continuously improve our value-added offering to you. So with the housekeeping items out of the way, let's take a quick glance at today's agenda for an overview and the topics that we will be touching on. The first topic is COVID-19 developments, what employers need to know. The second topic is going to be restrictive covenants, trending towards resolution. And the third topic is going to be pay equity, US and global developments. And now for the first topic, COVID-19 updates. You'll hear from both Remy's and Demia will kick it off for the discussion regarding COVID. So the four of you take it away.
Thanks, Bill. My name is Remy Balogan, and I'm going to kick off our discussion of COVID-19 developments. So we're going to start with the discussion of government mandates and prohibitions. So as I'm sure you know, the #1 topic in this area right now is vaccines. So a recent study by Willis Towers and Watson from last month found that 57% of all organizations said they either require or plan to require vaccinations. And that includes about 18% that currently require vaccinations, 32% that plan to require vaccinations only if OSHA ETS goes into effect, and 7% that plan to mandate vaccinations regardless of ETS, of whether ETS goes into effect. So what this means, and we know a lot of employers are asking, is can you require that workers are vaccinated or not? Do I have to? If so, do I have to for everyone or just for certain workers? What about privacy considerations? And these are all things we're going to hit on starting with this slide and the slides that follow. And to answer these questions, it's helpful to have a baseline of the understanding of the laws that are driving employer planning. So at a high level, we're talking about mandates and prohibitions. And the mandates are kind of in these 6 buckets that you see on this slide. And the first 4 are federal mandates. So we have the Federal Employee Worker Worksite EEO, which requires all federal employees to be vaccinated with no option to be regularly tested instead. The second is the Federal Contractor Executive Order, which requires that contractors must ensure that all covered contractor employees are fully vaccinated for COVID-19. The OSHA ETS requires that employers with 100 or more employees ensure that each of their workers is fully vaccinated or test for COVID on a weekly basis. And the fourth is the CMS, which requires that healthcare workers at facilities participating in Medicare and Medicaid be fully vaccinated. Next, category 5 is state laws. These are usually for certain employees. We've seen these mostly in the cases of healthcare and teachers. And lastly is local laws. And we see these mostly for certain more public-facing businesses. So you've got these for bars and restaurants, large events, et cetera. And we're starting to see citywide mandates, with New York City being kind of the star/notable actor in this area, where they have a citywide mandate for private employers. Guidance on that is actually anticipated to come out tomorrow. So we look forward to seeing how they anticipate implementing and monitoring that. So those are mandates. And the next category is prohibitions, which will be this slide and the following slide. And prohibitions kind of do the opposite of what mandates do, whereas mandates say you need to vaccinate. Prohibitions are limits, usually state-specific laws, which are limiting employers from implementing their own workplace vaccine mandates or requirements. When we look at those specific laws, they fall into a few categories. We see the kind of prohibitions that generally create some smaller or limited exemptions, whether it's an exemption for religious reasons, or medical reasons, like we see in Alabama, Arizona, Iowa, Texas, Utah, and West Virginia, or if you have a negative test or proof of immunity, like we see in Alabama, or for reasons of personal conscience, like in Texas. And the most strict prohibition would be Montana, and that's a standout because it essentially prohibits any vaccination as a condition of employment. And we flip through the 2 slides, so you'll just see that those are kind of the main category of state prohibitions. And at this time, I'm happy to pass it along to my colleague, Remy Sneed, to discuss federal and state litigation.
Thank you, Remy. We will turn now just to some ongoing federal and state litigation relating to both these mandates and the prohibitions. So unsurprisingly, there has been a wave of litigation relating to these vaccine mandates. What you'll see on this slide, only a couple of words, I know, but this is essentially the saga of the federal vaccine mandates. This slide kind of shows the applicability of COVID laws as they're constantly evolving because they're being challenged in the courts. So the first is the OSHA ETS. It's been challenged across the board by states, labor unions, industry groups, all essentially saying that OSHA has exceeded its power. It hasn't shown the grave danger required to be able to skip the more time-consuming and formal notice and comment procedures. The Fifth Circuit Court of Appeals has granted a motion to stay the ETS. So in response, OSHA has halted all implementation, enforcement of the ETS. And that decision is currently pending in front of the Sixth Circuit Court of Appeals, where that decision, along with some similar petitions across the country, have been consolidated. So the US Department of Labor has requested that the Sixth Circuit Court of Appeals lift the stay on the ETS, and a briefing was actually due last Friday on December 10th. So we can expect some sort of decision there pretty soon. The original ETS compliance deadlines, the first was December 6th, which has obviously come and gone. And the deadline for full compliance was January 4th. So we can expect that in the event the Sixth Circuit Court of Appeals does lift the stay on the ETS, that OSHA will pretty quickly give us some new compliance deadlines, but we can also expect that those new deadlines will have a pretty tight timeline because that's what we saw with the initial deadlines. Our second and third federal mandates are the federal contractor order and the CMS mandate for certain healthcare workers. Both of those mandates have also been challenged in federal courts in Georgia and Louisiana, respectively, and they are both currently blocked nationwide as well. Our fourth and kind of the last one standing is our federal employee worksite order. And that's the one that requires federal employees to be vaccinated, no exception for regular testing. That is currently in effect, although there is some pending litigation. The only court that has heard that issue so far is the District Court for DC, which declined to block the mandate. But again, there is some ongoing litigation to watch. So if we flip to the next slide, that's just kind of our 500-foot overview. We have the 4 federal vaccine mandates. As you can see, 3 out of the 4 are currently halted nationwide, with the only one in effect being the federal employee worksite order. However, that is subject to change pending appeals and the ongoing litigation. So another litigation trend we're seeing is litigation against these state prohibitions that Remy discussed. The effect of this is that even at the state level, employers really need to be aware of how this case law is evolving and what arguments employers are making against these prohibitions that have been the most persuasive to courts. So on this slide, we have just a sample case. Norwegian Cruise Line sued the Surgeon General and the Department of Health in Florida, trying to get an injunction against Florida's law, which requires collecting vaccination information, requiring vaccination, and was successful in obtaining an injunction. So the cruise line is still allowed to collect vaccination information from passengers. This case is a really good example of some of the key themes that we're seeing employers make in these cases. And if we want to flip to the next slide, there we go. They kind of fall into 3 buckets, the kind of key arguments that have proven to be pretty successful. The first, of course, first and foremost, as has been since the beginning of the pandemic, is public health. So the health and safety of employees, of patrons, of customers, anybody coming into a workplace or a business. The second is avoiding claims of violations of other laws, the complication, the interplay of various regulations, laws as you move from jurisdiction to jurisdiction. A cruise line is an amazing example of this because what flies in Florida might not fly as soon as you go over one state line. Moving through federal, state, international waters, you could very quickly be in violation of a different regulation. And the third is keeping a competitive advantage. This is important across all industries, but especially in customer-facing industries where there's a lot of face-to-face interaction. There are kind of 2 key harms here. There's the reputational harm. So in the context of a cruise line, if there's an outbreak on a cruise ship, that could very quickly be in the headlines, as we have seen throughout the pandemic. And there's also the financial harm. If there's an outbreak on a cruise ship, for example, having to cancel cruises, having to cancel cruises in the future, or you or I deciding whether we want to take a cruise for our next vacation. And I am now going to hand it over to Goalie to discuss what employers should be doing about this very confusing overlay of different state, federal, local mandates and prohibitions on vaccines and other COVID measures.
That's right. Thank you, Emmy. And my name is Goalie Rahimi, and I know we just threw a ton of information at you, but don't worry, we won't leave you hanging without some practical tips and considerations. So what are the next steps for employers in light of all of these recent COVID developments? What does this all mean? Essentially, as with many HR and employment rules, COVID or non-COVID, this is going to differ based on where your employees are, where your business is headquartered, the type of business that you have, and even how the litigation landscape, which Remy just talked about, is shaping the way that we're conducting human resources from this point onward. Now, to add to that chaos, our governments and leaders are constantly battling the changes affected by the new COVID variants, Delta and Omicron. And many are seeing a return to those early pandemic days. I can't believe we're 2 years from that first day, but we're going back into lockdowns in many jurisdictions with mask mandates, with social distancing obligations. So what does this mean for your business? If we can go to the next slide, how do we proceed in this step? So step one, understand which rules apply or are likely to apply to your employees and your locations. Figure out which ones are the ones that you need to watch out for and put the other ones to the side for this very moment. Step two, follow the legal development for that particular rule. You saw that timeline that Remy set forth in that slide. These rules are constantly changing. Some might apply to your business, they might not. They might apply today, but won't in a few months. So make sure you're up to date, and that's where our firm can absolutely help you with that. Step three, decide what policies, if any, your company will issue and what restrictions on that policy will be, especially if the policy is discretionary or mandatory, and that is usually governed by your local law. If your local law is silent on issuing some sort of policy, then it's really up to the business. Are we going to make sure that our employees wear masks? Are we going to force them to be vaccinated? And if so, how are we going to make sure that we comply with the law? And finally, draft and institute procedures that not only comply with these current laws, but also take into consideration any pending litigation, any anticipated new regulations, any pending bills that are sitting in the chambers of our government. Those are critical things to take into consideration. Now, our earlier slide showed how most of the pending federal laws have been halted nationwide. But if we look at this slide, there are several states that are attempting to pass their own vaccine mandates or bans on those mandates. So this is where the issue of preemption comes into play. The rule of thumb is that federal law will generally supersede any conflicting state law on that particular issue. And state laws can only be more restrictive, not less. So this is why we're seeing such a significant uptick in the state challenges to these federal mandates. You saw Remy put up that slide in chat, each state and the different rules that they're issuing in response to these federal mandates. But if the federal mandates are halted, then they're deemed unconstitutional and prohibited from going into effect, then preemption won't necessarily be an issue in those states. But in any event, if we are going to see these federal laws come into effect, we need to be ready. And one really good tip is to comply with OSHA. And OSHA has put out some template policies. They have both a discretionary vaccine policy and a mandatory policy. These can be easily found on their website. You can't go wrong if you use the template that's issued by the very agency that's making these laws. So assuming, for example, that the ETS does go into effect, what do? One consideration is collecting the data, namely the vaccination status for your employees. And that's on our next slide. So you're collecting vaccination status for all of your employees. So is HIPAA going to come into effect? A common misconception about HIPAA is that employee information is covered by it. But employers generally fall outside the scope of HIPAA, even if they're considered a covered entity. In fact, Health and Human Services recently issued a Q&A for businesses who have asked, can we inquire from our employees, our clients, our customers, if they're vaccinated or not? And HHS explicitly said HIPAA's privacy rule does not apply when someone is just asked about their vaccination status by their employer. So for employers who are collecting this vaccination information themselves, or for example, information related to an individual's request for an accommodation, it's critical to ensure that this information is kept separate from the rest of the employee files and accessible only to those on a need-to-know basis. If we go to the next slide, here are some practical recommendations to make sure you're complying with data privacy laws as you're moving forward with your vaccine mandates or vaccine discretionary policies. Make sure you collect the health information, as we discussed, only where it's legally required or absolutely necessary. Prepare detailed privacy notices, consent forms. Ensure these are given to the employees before the requests are made and before the information is given back to the employer. Apply adequate security measures. Make sure everything is under lock and key on your system and is not readily accessible to the rest of the HR department or the rest of the employee population. And ensure you're limiting your systems, access, and your retention locations and periods for this information. And with that, I'll turn it back over to Remy to address what to do when someone can't get vaccinated.
So step 6 here is understand and handle and process exemptions. So the key is that employers need to have a process under which and by which they handle requests for exemptions. You don't necessarily need to grant every request for an exemption, but you need to have a process in place on how you're going to handle them. And there's 2 primary types of exemptions: medical and sincerely held religious beliefs. So the employer is going to want to consider, does the employee meet the exemption? Is there a reasonable accommodation that does not impose an undue hardship? And if the answer to both of these questions is yes, then you'll want to provide that reasonable accommodation. So turning first to medical and disability accommodations, you want to provide a form for the healthcare provider to complete. And there are relatively narrow circumstances, and those are employees for whom a vaccine is medically contradicted, employees for whom medical necessity requires a delay in vaccination, or employees who are legally entitled to a reasonable accommodation under the law because they have a disability. And then the other category is accommodations for sincerely held religious beliefs. And we want to provide a form to the employee with questions about the sincerely held religious belief. And the thing here is that it might be tempting to question whether or not something is a sincerely held religious belief, but we don't want to do that. So in the context of vaccines, it's a little bit different than the sort of textbook examples you remember from law school, where it's time off to attend a service or time off to pray. It's really about what that individual believes. And the guidance makes clear that an employee who has a newfound religious belief, it doesn't mean it's illegitimate. And that if the employee is the only person in their religious group who seems to hold the belief that vaccines are against their religion, that also doesn't mean it's not a legitimate religious belief. So in this space, rather than try and question the sincerity of a religious belief, you'd want to focus on the undue hardship element and rather than the religious nature of that belief. So an undue hardship is an affirmative defense under federal law, and it's a very low standard, and any de minimis expense or disruption likely would fall into that category. But certain states have stricter hardship standards, and you might need to have more of a burden to show that something's undue hardship, similar to the ADA disability standards. If we move on, there are some best practices to consider in accommodations. So those would be: ask an employee to submit the request for an accommodation in writing and provide a standard company form for them to do this. Determine whether the religious belief conflicts with the vaccination policy or whether the disability or medical need requires an accommodation. Specifically for disability accommodation, determine the essential functions of the job. If the individual cannot perform the essential functions of the job requested with the accommodation, then the company does not have to provide that particular accommodation. And when exploring potential accommodations, we want to consider pandemic familiar measures such as remote work, testing, masking, social distancing, the installation of barriers, one-way hallways, the sort of things that we've seen so far in the pandemic. Another consideration would be to encourage employees to propose their own accommodation when submitting their requests. We want to make clear that just because you propose an accommodation doesn't mean that the company is obligated to accept that specific accommodation, but to the extent employees do propose reasonable accommodations that wouldn't be an undue hardship and are things that the company can implement, that can be a helpful tool. And then when considering whether an available accommodation would cause an undue hardship, be sure to apply the correct standard. And then you want to check in periodically to see whether or not the accommodation is still necessary. So one thing we discussed earlier is that sometimes you can't get vaccinated because a medical condition currently requires a delay. So you want to follow up on those sorts of things just to make sure that the accommodations you're providing are still well suited to that employee's need or still necessary. So I'm again going to hand it over to Remy Sneed this time to talk about some additional steps employers should take.
Okay. Step 7, this is just your friendly reminder not to forget about testing, masking, social distancing, a lot of the measures that employers have been using since the very beginning of the pandemic to keep workplaces safe, regardless of the status of the ETS or any other regulations. It's also important, just as important now as it always has been, to track state and local regulations. County, city, there are a lot of localities that are, especially given the recent uptick in cases, still issuing their own either requirements or recommendations relating to masking, social distancing, health screening, various measures in the workplace. We're also getting quite a few questions about the cost of testing, both who pays for the cost of the test itself and who pays for the time to get tested and traveling to and from a testing site. So who does pay? This is everybody's favorite answer. It's really a state determination. You need to look at specifically what state you're in. With respect to the cost of the test itself, there are many states that have laws that apply to applicants or employees or both, which state that employers must pay for a medical exam. There are also states, California is an example, where it's an indemnity. So employers must reimburse employees for expenses incurred in carrying out their work duties. Specific to Illinois is a great example. The state prohibits employers from requiring employees to pay for the cost of a medical exam that the employer requires as a condition of employment. So the State Department of Health has issued pretty explicit guidance stating that employers with mandatory routine COVID testing programs have to pay for the cost of those tests. With respect to timing, non-exempt employees probably need to be paid for the time spent traveling to, getting the test, and traveling back. Under federal law, we don't have a clear-cut answer, but we do have some guidance which points to a likely yes answer. It's likely that employers do have to pay for this time spent getting a test. And again, some states have their own guidance, some explicit mandates. For example, California makes it clear that employers must pay for the time spent for employees traveling to the testing site, time spent getting the test, and time spent traveling back from the testing site. This is true regardless of whether the employees are being tested during normal working hours, scheduled working hours, outside of working hours, in the evenings, on the weekends, whatever it may be. And I'm now going to pass it to Damia to discuss some Illinois-specific state and local laws to keep in mind.
Thanks, Remy. Okay, this is going to be a quick but important refresher. In Illinois, there are sick leave laws at the state and local levels that employers should keep in mind. As many of you know, Illinois does not have a law requiring employers to provide paid sick leave, but if employers choose to provide sick leave, there are certain requirements to follow under the Illinois Employee Sick Leave Act. I'm going to call it ISLA. Under the ISLA, if paid sick leave leave is provided, employers should allow employees to take personal leave when they are sick or when their family member is sick. So starting from April 2021, there is one more qualifying reason available under the ISLA, that is personal care of the family member. What that means is that now employees can take leave to help with their family members' basic medical or safety needs, or employee can drive their family members who are not able to drive themselves to medical appointments. Personal care also means being physically present to provide emotional support to a family member with a serious health condition. But note that employers can limit the use of sick leave for the purpose of taking care of a family member to the sick leave accrued during 6 months. So for example, if an employer offered 40 hours of paid sick leave per year, that means the employer could limit paid sick leave used for family members to 20 hours per year. Next item is, unlike the ISLA, under the Chicago Sick Leave Ordinance, employers in the city of Chicago must provide paid sick leave. The Chicago Paid Sick Leave Ordinance was recently amended to expand the reasons for leave, And now employers should allow employees to use paid sick leave to care for a family member who is quarantined or to stay home themselves. Next slide, please. Chicago and Cook County also have anti-retaliation provisions. Just to quickly point out a few important items. Chicago employers, you cannot retaliate against employees because they comply with public orders related to COVID. Employers in Cook County, you cannot take adverse actions against an employee for taking time during a shift to get a vaccine. With that, I'll turn it over to JT, Leeds, and Goalie to discuss one of the hottest topics, restrictive covenants.
Thanks, Demia. We're going to switch gears a little bit now and talk about restrictive covenants and some trends we've been seeing across the U.S. But first, we have a polling question for you, if we can get that up. All right, and the question is, has the U.S. trend in restriction of non-competes changed your company's approach to non-competes? And what I want you to think about there is what you've done, if anything, in response to new laws or pressures that you've had over the past years with how you treat non-competes, whether it's changing languages, changing the language of the agreements, or potentially limiting who those agreements are applicable to. And I will give everybody a few seconds to answer that question. All right, the results are in. It looks like the majority of us, about 53%, says they've taken some measures to change their approach to non-competes, which is really consistent with what we've been seeing across the US. We can go ahead and go to the next slide. Over the past 5 years or so, there's been a real push from the state level to curb the use of non-competes. And the focus has really been on the use of non-competes with respect to low wage earners. The struggle for those employers with employees in multiple jurisdictions is there's no one way that these states have defined low wage earners. Some states take the approach of low wage earners are those employees who are at minimum wage or maybe some incremental level above minimum wage, while others have set much higher thresholds. For example, the state of Washington, employees, you cannot use non-competes with employees who earn, I think it's about $107,000 or less. So you can see that the differing approaches and the struggles that it presents for employers. In addition to the kind of focus on low wage employees, there's kind of two key things that we've been seeing states focus on when they're enacting new legislation on this topic. One is many states are requiring employers provide notice of the employment agreements and explicitly advise these employees in writing that to seek counsel prior to signing or agreeing to any non-compete agreements. And the other key trend we've been seeing is many states are limiting the enforcement of these non-compete agreements to employees who are laid off or otherwise separated from employment, involuntarily separated from employment. And then more recently, we've started to see a bigger push on banning non-compete agreements outright. As many of you may know or may have heard, in about a year ago this month, Washington, D.C. Passed what's thought to be the most restrictive ban on non-competes in the country. Essentially, employers in Washington, D.C. cannot use non-competes outside of a few small exceptions any longer. And as many of you have heard earlier this year, the Biden administration set out an executive order directing the FTC to issue rulemaking that curtails the use of non-compete agreements. Now, the executive order isn't law, and we haven't seen any rulemaking from the FTC yet, so it's not clear whether it's going to lean more towards the banning non-competes outright or whether it's going to be kind of a more measured approach like some of the states have taken with respect to income thresholds and other requirements for non-competes to be enforceable. if we can go to the next slide. And so what do you do as an employer with, employees in multiple jurisdictions or locations across the country? Here's some key takeaways that you should be considering right now. I won't read through all of these, but there's a few I wanted to highlight. One primarily is to educate your managers, especially those managers who are responsible for hiring employees and candidates. As I mentioned, a lot of these new non-compete laws have notice provisions, whereas you have to provide the employee or candidate 10 days, 14 days notice. And if you don't, that agreement is going to be unenforceable if that employee ever leaves. Another is consider the impact of widespread rulemaking on how you want to handle and manage your key employees, your key customers, and your trade secrets. If non-competes do go away, or if the FTC issues kind of a widespread ban on the use of non-competes, we still want to make sure we can protect our key clients, protect our key employees, and protect our trade secrets from leaving when an employee leaves. So should you put more emphasis on confidentiality, non-disclosure agreements, or other methods of protecting those assets after a company or after an employee leaves the company? And then Illinois has also kind of been on trend with these other states, and recently, if we can go ahead, recently enacted some amendments to the Illinois Freedom to Work Act. Many of you with locations in Illinois are probably aware that the Freedom to Work Act was passed back in 2016 and essentially limited or prohibited the use of non-competes with respect to employees earning minimum wage. This year, Illinois amended that act to kind of increase that income threshold and set some additional requirements on the use of non-competes for employees in Illinois. It goes into effect in a couple weeks here at the beginning of January, and changes that threshold from minimum wage up to $75,000 per year in order for non-competes to be enforceable. That $75,000 a year number increases, I think it's every 5 years until it ultimately hits $90,000 per year in 2037. Illinois, unlike some other states who specifically carve out non-solicitation agreements from their non-compete acts, Illinois has specifically included non-solicitation agreements. So in Illinois, starting in January, employees who makes $45,000 per year or less cannot be subject to a non-solicitation agreement. Like the non-compete agreements, that number also increases every 5 years until it hits $52,500 in 2037. Some other unique aspects of the Illinois law include this definition of adequate consideration. In Illinois, as many of you may know, for a non-compete to be enforceable under the current case law, it requires 2 years of continuous employment by the employee. So if an employee is fired or voluntarily leaves after 1 year, that non-compete agreement is not enforceable against him or her unless they were provided other consideration. Now, other consideration is kind of a nebulous term, and it's not really clear what that means. But it's the same type of language that's used in the new act. So if that employee was given, for example, $1,000 in exchange for entering into a non-compete agreement, will that be sufficient other consideration if that employee leaves in less than 2 years? We think so, but we don't know. It's still to be determined. Another kind of unique aspect that was included, or I guess not included in the new Illinois Non-Compete Act, is the scope of the agreements that are prohibited. Typically, we see states specifically exempting things like severance agreements from the definition of non-compete agreement. Illinois didn't do that. So as it's currently written, even a severance agreement that contains a non-compete agreement would be unenforceable if it doesn't meet the other aspects of the law. Another thing that Illinois did not do is did not specify that non-compete agreements are restricted to post-employment activity. Many states, such as Massachusetts, expressly say that these agreements cannot prohibit employees from engaging in certain activities after they leave their employer. Illinois does not include that type of language, And so as written, prohibiting employees from competing during their employment is also going to be a no-no unless the agreement meets the other requirements under the act. So we can go ahead and go to the next slide. So what do we do in Illinois? What are employers to do come January or now in preparation for January? As you'll see, many of these takeaways are very similar to the takeaways we just discussed a couple slides ago. But I did want to highlight this third bullet on limiting the extraterritorial scope of the new law. You know, under the current Illinois law, it's relatively favorable with respect to the enforcement of non-compete agreements. So, you know, many employers will use, when there's a connection to Illinois, whether it's the location the employee works in or potentially state of incorporation, employers will use Illinois law as the governing law for non-compete agreements. With these new limitations going into effect, employers may want to reconsider that and look at other potentially more favorable law as they move forward with non-compete agreements after January 1st. With that, I will turn it over to Liz and Goli to talk about global non-competes.
Thanks, JT. So we'll venture outside of the United States briefly and talk a little bit about non-competes and what you can expect globally. As we know, many of you have operations outside of the US. We can start with Europe, but non-competes in Europe are typically allowed just to protect a company's legitimate business interests, with some exception, and approaches can really vary. So it's really tough to do a one-size-fits-all approach globally, and then again, even more on a more tailored basis, even in the continent of Europe or the region of EMEA, it's very difficult. Other kind of guiding principles to keep in mind that are very common throughout EMEA are that preliminary injunctions can be hard to come by in civil law countries where liquidated damages and penalty clauses are often used. And within the EU, we generally recommend considering the following factors, and most courts and governments will take into account the following factors to determine whether a restriction would be enforceable or not. And that's limitations on geographic scope and limitations on duration. Typically, we don't see anything in Europe that can exceed 2 years and still be enforceable. We also need to have requirements of legitimate business interest of the employer and support for ongoing compensation during the non-compete period. There are a number of jurisdictions in Europe that actually require very specific compensation during the restricted period, which may be a percentage of base salary, of the highest base salary paid during the term of employment. And it may also be the full amount of base salary that was paid during the term of employment. So that really varies and is generally a little bit more strict than what we see in the United States, save for a couple of jurisdictions. Like, as I mentioned, several EU countries do require separate post-termination compensation. And yeah, so what are we going to see in the future in Europe? All eyes are really on the UK. There's a commission that's considering the possibility of major reforms, including going as drastic as taking the California approach, basically prohibiting all non-competes unless somebody's a seller of a business. And then in the Nordics, countries continue to whittle away at template agreements. So they really disfavor use of templates that are applied across the board and expect to see really bespoke restrictions for each employee that are narrowly tailored to that individual's role, their knowledge of the company, and that sort of a thing. So there is movement in Europe. It does seem to be very similar to what we're seeing in the United States, with a couple of little nuances and probably a few more rules than you might be used to here in the US. Next slide. And what can you expect to see in Canada and in Latin America? Just at a high level overview, Latin America generally disfavors non-competes and customer non-solicitations. These are almost always unenforceable in Latin America and very, very difficult to use. Some employers choose to use them for deterrent purposes, but in practice, we really caution that they can't be relied on. And employers in Latin America, what do they do instead? They typically focus on trade secret misappropriation to challenge employee disloyalty. And it is possible to leverage both the civil and criminal courts, depending on the facts. So that's really where you try to move to in Latin America, is to use this trade secret misappropriation concept rather than relying on more traditional post-termination restrictions. Canada, less good news for employers, so more bad news, I suppose we would say, for employers in Canada, is that Canada is recently shifting to be a more employer-friendly jurisdiction, to a jurisdiction where post-termination restrictions are increasingly difficult to enforce. So non-competes are generally permissible if they restrict the employee's activities as minimally as possible and go no further than necessary to protect the employer's legitimate business interest. But there is proposed legislation in Ontario that would significantly change the enforcement landscape and again, make it much harder for employers to rely on and enforce these types of provisions. So I suppose we would say that the global trend is moving towards making this harder for employers to rely on post-termination restrictions. And I'll turn it over to Goli and she can give us a brief rundown on what's happening in APAC.
Thanks, Liz. So the last major OUS region where we're seeing these non-compete trends or a shift away from non-compete enforceability is APAC or Asia Pacific. So as with non-competes in other jurisdictions, and as we're seeing in the US, is like JT mentioned, non-competes will not be held enforceable unless they're supported by adequate consideration. They're reasonable in light of the circumstances. And in most APAC countries, this means narrowly tailored, not only to the employee, but to the business and the location where the business is involved, and to protect a legitimate business interest. Certain countries have their own more stringent limitations, such as Hong Kong, where the maximum duration of restrictive covenants is generally much shorter than in other jurisdictions. We're seeing less than a year, except in very odd unique circumstances. And China, which is very much like Europe, where most courts will generally require post-termination covenants to be supported by some sort of additional percentage of salary or additional consideration. And one trend that we're really seeing is the drafting of these non-competes. If a certain provision is or is not in a non-compete agreement, even if there are other clauses in that agreement, the whole thing can be considered void by a court. Courts are moving away from blue penciling in our OUS jurisdictions. So it's really critical that each document is tailored correctly. And if we go to the next slide, we can see some more practical considerations. You can see in that second column, as Liz mentioned, one size is no longer going to fit all. Template non-competes, template restrictive covenants are no longer going to apply in these jurisdictions. It's clear that what we need to go through is a careful planning, pre-planning, thoughtful process before you ask an employer to sign a non-compete. Employers need to balance their company needs against the employee's right to make a living, remembering that this one-size-fits-all model is no longer valid. Especially in the OUS jurisdictions, it's critical to separate restrictive covenants, for example, from equity awards, because when you're calculating end-of-year severance or end-of-year end of employment indemnities, you want to be able to successfully argue that equity is not part of local compensation. So you don't want to, have that information or have that amount calculated in your labor benefits, including severance. I think it's very clear to all of us that non-competes are becoming more and more difficult to enforce. And what's interesting, a trend that we're seeing is many companies are actually using the lack of a non-compete or a very short, unburdensome non-compete as a recruiting and retention tool, especially in this day and age. But if your company has already decided, look, we're going to have a non-compete in this country or in this region because this is where our business is most powerful and most revenue generating, then be ready to enforce it. Be serious about enforcing it if it's breached or if there's a threat of a breach, because you don't want to send a message that this company is not serious about enforcement. So consistency is key there. And with that, I will turn it over to my colleague, Daniel.
Thanks, Goli. Now we're going to talk about pay equity, US and global developments. Before we jump into this exciting discussion about pay equity, we actually have a polling question for you. Kelsey? Yeah, the question is, what steps does your company take to try to achieve pay equity internally? Do you conduct regular compensation audits? Do you conduct regular performance rating review audits? Do you train managers, supervisors, or HR on applicable requirements or restrictions, or something else? We'll give everybody a couple of seconds to take the poll and circle back. Kelsey, could you launch the poll results? Yeah, it looks like, 39% conduct regular compensation audits. That is very good. So as the result indicates, it looks like this pay equity issue is on many employers' radar. Next slide, please. Now let's turn our attention to salary history bans. This year only, Nevada and Rhode Island joined the other states prohibiting employers from asking about a job applicant's salary history. And many states, including Illinois, Colorado, and Connecticut, continue to develop their pay equity laws by adding or revising employers' obligations. Next slide, please. Many states also have reporting requirements with respect to pay equity as well. Specifically in Illinois, any business that is required to file an annual EEO-1 report with the EEOC, which includes all private sector employees with 100 or more employees, they must report employee demographic and pay data information. There are other states that have reporting requirements, such as California, of course, but the Illinois law goes even further by requiring employers to obtain certificates called Equal Pay Registration Certificate. So effective June 25th this year, private employers with more than 100 employees in Illinois must obtain the certificate from the Illinois Department of Labor between March next year and March 2024 and recertify every 2 years afterwards. But if you have employees in multiple locations or facilities in Illinois, you can submit a single application regarding all their operations in Illinois. But note this, just because you have received the certificate, that does not mean that you are in compliance with state and federal equal pay laws. So unfortunately, you won't be able to use the certificate as a defense against any violation of the equal pay law or mitigate any sort of damages, but you will be able to show that you have met the certificate and reporting requirements. Next slide, please. In addition to mandatory reporting requirements, voluntary reporting is also trending. It's called Arjuna reporting is one example. To provide more background, Arjuna Capital is an investment firm and they requested race and gender pay equity disclosure by submitting multiple shareholder resolutions. So to date, many leading US corporations have positively responded and agreed to provide gender pay gap disclosures voluntarily. These companies include Citigroup, MasterCard, Starbucks, or BNY Mellon, or Adobe. So this was what's happening in the US. Now I'll turn it over to Liz to discuss the global trend.
Thanks, Damia. Next slide. So we'll do a quick trip around the world on pay equity requirements that are currently existing. As many of you know, pay equity continues to be a very hot topic outside of US borders, and there are jurisdictions in every corner of the world with pay equity laws and or reporting requirements. We highlight a few of them here, which I'll talk about briefly. Most of you may be the most familiar with the UK pay equity reporting requirements. They have strict reporting requirements on the gender pay gap, and this has been in effect since April of 2017. Essentially, companies with more than 250 employees need to report their gender pay gap both publicly and to the government. It's usually available on a company's own website. Again, once you have the 250 employees in the UK or more. So that's been there, it's around, it's still there, it's still kind of a pain, but it's just becoming more of a habit, I think, for most companies that have this size of operation. Australia also has a reporting requirement. It's a little bit different and more nuanced in that the government publishes aggregated pay gap data from which individual companies cannot be identified, but companies still have this obligation to submit the information. Iceland also has reporting requirements, which shifts the responsibility of proving that there's no income discrepancy between men and women onto the employer, requiring all public and private organizations with more than 25 employees, so it's a pretty low threshold, to be independently certified as paying equal wages for work of equal value or face daily fines, and the reputational impact of violating the law, of course. And then we also have France. Beginning in March of 2019, companies with more than 1,000 employees were required to report on their websites the score they receive on a gender pay index that comprises 5 gender-related criteria, with sanction as high as 1% of the employer's total monthly payroll. So that's nothing to ignore. That could actually be a very significant penalty if it were actually faced. If we go to the next slide. So pay equity it's not a static issue at all globally. There are lots of countries that are still trying to find creative ways to address the gender pay gap, which continues to persist. In January of this year, so almost a year ago, Spain enacted new regulations which reinforced the principle of equal pay for equal work of equal value. So they've introduced specific criteria or factors for assessing jobs, which will require gender-based review of existing company policies for job assessment. In particular, companies that draw up equality plans will have to carry out or review existing jobs in order to comply with the pay register and pay audit obligations. We're also seeing, this may be a little bit of a surprise, but we're also starting to see some new laws take effect in the Middle East. Not all of these laws are pay reporting requirements or something similar like that. They're taking a slightly different tack in that for example, the UAE has issued some new laws prohibiting discrimination. So they've also introduced paternity leave in the UAE to try to help ease the discrepancy between men and women taking time off work to care for a child, and also granting female workers in Saudi Arabia further rights in the workplace, including special accommodations for working in hazardous workplaces and at night. So countries are approaching pay equity with, I think, the same goal in mind, but doing it in slightly different ways. Could we go to the next slide? One thing we wanted to flag was that there is proposed regulation in the EU on the EU Pay Transparency Directive. This was proposed in March of this year. If passed, it would likely be implemented in 2024, so you've got a little bit of time. But the directive would reinforce the entitlement to equal pay for men and women for the same work or work of equal value. I'm not going to read each of the rules that would be included if this was adopted. A few highlights to think about are that this would apply to employers with 250 or more employees. And it would also include gender pay gap reporting for employers with more than 250 employees. And it would also create joint pay assessments if the gender pay gap reporting is greater than 5% for any category of worker doing the same work or work of equal value, and the employer was unable to justify that gender pay gap. And what that, if you could go back. And what that actually means is it's a procedure that the employers with at least this 5% difference in average pay would need to go through with workers' representatives, labor inspectorates, and equality bodies to analyze the gap and ultimately remedy it. So the employer would have an obligation to work with these third parties to try to figure out what's going on there and remedy the gap. It sounds like a real pain and a good incentive for everybody to try to get their house in order on this front. So again, if this takes effect, we aren't expecting it to be to come into effect until 2024. So you've got a little bit of time on that one. We could go to the next slide. Right, so what this would basically do is this transparency directive would require companies that maybe are not operating in countries like the UK where there's already a pay gap reporting requirement. It would impose this pay gap reporting requirement on employers who have operations in other jurisdictions. So it would really broaden it and increase the burden on employers. And again, I think it would pose a real challenge and be very burdensome, but all towards a very amiable and outstanding goal. But I think it would just be very challenging for employers to the extent this actually takes effect. So a few takeaways for everybody to think about. This goes back to our polling question that Damia shared earlier, which it sounds like a lot of you are already doing, is to conduct annual compensation audits already and ensure that the audits are conducted across all jurisdictions. We can certainly help you with that. There There are lots of nuances and things to take into account when you're working in different jurisdictions, including data privacy and what kinds of data you can actually look at. For example, it's very uncommon to actually do a pay gap based on ethnicity or race outside of the United States, because it's very difficult to actually collect that data from employees. So we typically only do gender outside of the United States. Also, important things to do include auditing incumbents compared to new hires when hiring, to make sure that the incumbents are being paid what the market actually demands. We see that a lot in pay audits, is that folks who have been around an organization for a long time often just sit stale in a role and aren't brought up to what the market is actually demanding, which can lead to a discrepancy. Keeping on top of and complying with local and country requirements and adjusting policies and practices and reviews according to your jurisdiction. So we've got this new Illinois law coming and some new obligations outside of the US as well. And then another thing that some companies do, we see maybe a little bit less frequently, but is considering more frequent kind of mini audits of populations that may be historically more impacted, or you might see just larger discrepancies within a particular pocket of the organization, and conducting performance ratings and review audits as well. So these are all really helpful tools that can help you stay on top of gender pay gap and other pay gap reporting requirements, and also just trying to close that gap, which I think we're all trying to work towards doing. So with that, I think that's the end of our pay gap or pay equity reporting section, and I can turn it over to Brian.
Thanks, Liz. Thanks to both you and Damia for this last session, and thanks to all of our panelists for the information that you've shared here this afternoon. For those of you who don't know me, my name is Brian Wojciechowski, and I'm the chair of the Employment and Compensation Practice here in Chicago. And for those of you that are looking to collect Illinois CLE for today's session, rest assured that you're not going to need any type of code to claim that CLE. Next week, the Chicago ACC chapter will distribute a certificate for your CLE credit for today's session, to the extent that you completed the right information when you registered for the session. If you're looking for CLE in any of the other states, I'm going to give you a code right now, so write this down. And the code is L as in Larry, G as in Gary, 7710005. Again, that's LG 7710005. And following today's session, we will be distributing materials, including the CLE forms that you'll need. And that's the code that you should insert on those forms when seeking the credit. As a final comment, for those of you who may not already know, there is a part 2 to our 2021 Illinois Employer Update that will occur this Thursday at 1 p.m. Thursday's session will focus on compensation and benefit issues, as well as immigration and mobility issues. And we would be delighted for you to join that session. There is the link that's appearing on your screens that you can use to register that program. And again, we would be delighted to see you again on Thursday for some additional updates. Okay, so again, thanks to everybody for joining here this afternoon. It looks like we've got a little bit of time and we've got a couple of questions. So maybe if I'll tee up a couple of questions for our panelists and we can get some further feedback. So let's see, one question here. Have you seen companies that are using the same basic non-compete agreement for their operations all over the world, and then using some type of an addendum that is used to reflect jurisdiction-specific modifications. Is this something that companies are doing, and frankly, can it work? Maybe if I can open that up to the team.
Yeah, thanks, Brian. I can take a stab at this one. So what we're seeing with our clients who use what we call a one-size-kind-of-fits-all approach, we're taking two steps essentially. The first one is the addenda approach, where you have the body of the restrictive covenant is the same. It doesn't change. It's very static. But there is an addenda or an exhibit at the end of the document, and each of the hot sections, so it's the compete section, the non-solicitation section, what have you, that can be a little bit different in each jurisdiction, is referenced in the addenda. So you will have, for example, in the US, you will say Illinois. If you work in Illinois, or if you are an Illinois employee, section X is revised to read blah, blah, blah. So these are very high-tech words that I'm using. So that's one approach that our clients are using. The other one is what we call a cut and paste approach, where again, you have a very static body of the restrictive covenant agreement, but in each of the hot sections, you are cutting and pasting the appropriate language, the appropriate prose that would be enforceable in a particular jurisdiction. So either the law firm would do it or you would do it. So each document that goes to the employee is enforceable for them. They don't have an addenda, they don't have an exhibit. Both of those are common approaches we're seeing. It's more difficult OUS. You can't plug and chug quite as easily, especially as I mentioned earlier in the presentation. If certain language is missing or if certain language is included in these non-US restrictive covenants, it can invalidate the whole thing. So you have to be a little bit more careful with one of these two approaches, OUS, but that's the approach that we're seeing, especially as each jurisdiction is slightly different than the next. So we want to make sure that that one document we give to employees is enforceable wherever they are.
And Goli, one thing I wanted to add was just outside the US, in many jurisdictions where compensation is required during the restricted period, a lot of companies might start off thinking, oh, that's fine, I can put in compensation, and then when the person leaves, we can just elect not to pay them. And that's not always true. There are many jurisdictions, Germany is one of the ones that comes to mind that we run into a lot of trouble with, is that the company cannot always unilaterally waive its obligation to pay during the restricted period. In other words, when the employee leaves employment, they have a right in some countries to be paid for not competing, and the employer can't just say, oh, it's okay, you can go compete and we won't pay you. That doesn't always work. So it's particularly important to make sure that you're across whatever the compensation requirements are in a jurisdiction, so you don't paint yourself into a corner where you're paying for people to have a non-compete that you can't get out of, and you have this ongoing obligation to keep paying them if you really don't care if they're competing.
No, that's really helpful, Liz and Goli. Here's another question let me pose to the group. And this is focused on the pay audit discussion. What are some of the tips and ideas that companies should keep in mind when they're thinking about implementing some type of compensation audit outside of the United States? I know this is a topic that is coming up with greater frequency these days. Any thoughts?
Sure. So I would highly recommend, one of the hardest things to do on a pay equity audit, whether it's global, outside of the US, or in the US. Let me take a step back. First, I would try to understand what countries you have a governmental reporting obligation in, and then you're going to need to fix that and make sure that you're across that issue first. If you're also doing a pay equity audit, just to make sure that your own internal practices are correct, a couple of things to think about. One, make sure you've got somebody on your data privacy team who's working with you about what data you can collect, you have permission to collect, how you're using it, and how it's being transferred, just to make sure that you don't inadvertently create an issue with data privacy while you're trying to do something that's actually good and for everybody's benefit. The second thing to think about is really making sure that the cohorts of employees that you're looking at make sense. So it may make sense at some point to look at, for example, if you have country managers, you're probably only going to have one country manager or 2 or 3 country managers in a particular country. So you may need to compare them across countries. And then you have to start taking into account some other factors like how much are they being paid in a particular country? Does it make sense? Can we even compare these people? So trying to identify the cohorts on an OUS employment pay equity audit is a little bit tricky. And you may end up with categories of employees that you either have to compare across countries or that you decide not to compare at all because there's nobody that can be a similarly situated comparator for that particular individual. But I think those are kind of the big categories to think about. Like I said earlier, you probably won't be able to do any kind of ethnicity or race analysis just because it's virtually impossible to collect that data outside of the United States. So we're typically limited only to gender when we're doing OUS audits. But I'm happy to answer any other questions or talk to anybody offline about pay equity audits. I love that stuff.
Well, again, everybody, thanks so much for joining us here this afternoon. On behalf of our North American Employment and Compensation team here at Baker McKenzie, as well as the ACC chapter here in Chicago, we thank you again for joining us for today's part 1 of our 2-part webinar series. Again, part 2 will be on Thursday at 1 p.m. and we'll address compensation and immigration topics. We hope the information that we shared with you this afternoon was helpful. If there are follow-up questions or anything that we can do to help you address some of the questions that have come up, please reach out to any of our panelists here this afternoon. Following today's session, we will be circulating materials related to the webinar, as well as a very brief program evaluation that we would greatly appreciate your completing so that we get some feedback on today's session. And with that, I thank you again for joining us, and I hope everybody has a good rest of the afternoon. Thanks again, everybody.